So thank you very much, Ondi. Ladies and gentlemen, as we have come to the end of this very insightful session, I would like to take again a moment to extend our deepest gratitude to the esteemed panelists, Iga, Elizabeth, Andre. Your perspective and expertise have been incredibly valuable. We really appreciate your time and effort you dedicate to share your knowledge with us today, and also you get to come from Switzerland. So thank you very much. Thanks also again to Mondi for chairing this session. So now, as we move forward with our program, I'm really honored to introduce our keynote speaker for today, Professor Damilola Olawuyi. Is Professor and UNESCO Chair on Environmental Law and Sustainable Development at the Hamad bin Khalifa University in Qatar. He's also the Director of the Institute for Oil, Gas, Energy, Environment and Sustainable Development at the Damilola University in Nigeria. He researches and teaches in the field of climate change, natural resources, energy, environment, and business human rights, with a focus on Africa and the Middle East. His recent book, Environmental Law in Arab States, published by Oxford University Press, received the 2023 American Society of International Law Certificate of Merit for High Technical Craftsmanship and Utility for Practicing Lawyers. So I think quite useful also for us. He's an independent expert of the United Nations Working Group on Business Human Rights and Vice Chair of the International Association and Chair of the Association of Environmental Law Lecturers in Middle East and North African universities. So as you will see, we are really fortunate to have Professor Olawuyi with us today to share his insights on access to remedy for corporate harm in Africa, prospects and challenges of climate litigation. Please join me in welcoming Professor Olawuyi.
Thank you very much. Thank you, Dr. Ivano, and thank you to the organizers and team for such a wonderful conference, and thanks for inviting me. I have been privileged to listen to the very, very topical discussions that have been going on since yesterday and of course this morning. So it's been, I think this is a very wonderful opportunity to reflect on the potency of corporate climate litigation in advancing the business and human rights agenda. And so it's my privilege to bring you compliments and greetings on behalf of the United Nations Working Group on Business and Human Rights. As Ivano mentioned, I'm a member of the working group, member representing African states. So, of course, a discussion on Africa, climate litigation strategy in Africa is of great importance to us. So I'm happy to be part of it. So what I've been listening to the panelists, and I think they covered a lot of the points, that I was hoping to touch on. So I think, the insights they provide mean that what I will do now is just to do a sort of a recap of the lessons that we can take away from this early morning session, at least this morning session, which will include the discussions of the panelists as well as my own take, also bringing some perspectives from the working group. So I will start at least by providing some overview of our working group in case you don't know. Of course, I don't think there's anyone in the room that would not know about our working group and what we do, but I'll just provide some information and how we think about this issue of corporate climate litigation as well. Then I will talk about some of the claims that we are seeing, including the communications we have been receiving as a working group on corporate responsibility for climate change. And then I will talk about how to address some of the gaps and challenges that we see, especially in the African context, building on some of the points already made this morning. And then I will provide some perspectives and conclusion on the way forward, especially in the next decade, as we think of how to maximize the full potential of litigation to bring corporations to account for corporate arm in their operations. So the working group, as you may know, was established in 2011 when the United Nations adopted the UN Guiding Principles on Business and Human Rights. And as you already know, the UNGPs represent the authoritative standard on what responsible states and businesses should do to address corporate corporate violation of human rights, whether you're talking about any economic sector. As a matter of fact, the UNGPs cover a wide range of issues, focusing on the importance of highlighting human rights violation by businesses. Before the UNGPs, for many years, the focus, when you talk of human rights violations, we tend, the focus was on states, what states should have done better and the likes. But I think what the UNGPs have done is to focus on businesses themselves as force for good and as actors that could indeed influence a change in this area. And of course, as part of that, the working group was established to disseminate and ensure the implementation of the UNGPs. And our working group is made up of 5 members, like I mentioned, myself being the member from Africa. We have members from other regions. As part of our work, we conduct country visits to understand progress made and the challenges that remain when it comes to the UNGPs. And over the last years, we've conducted about 18 of those, including to Kenya, to Ghana, to Liberia in the past, and of course to other countries. And last year we were in Japan and Argentina, and later this year we'll be in Colombia. So as part of our mandate, we also release reports, thematic reports covering different topics. And we've done reports recently. Last year, I presented our recent report on extractive sector, just transition and human rights. I presented that to the UN General Assembly. Normally, we present 2 reports every year, one to the UN General Assembly and one to the UN Human Rights Council. So we recently did another one on ESG and investors. So I would encourage everyone to download these reports online. They are available to guide. And of course, in these reports, especially the one on ESG and the one on just transition, we did highlight the role of corporate climate litigation and how we can maximize its full value as part of our recommendations. So I would say, if you've not seen both reports, you should download them online and read them. Of course, one important aspect of our work that is related to this summit is our communications procedure, through which anyone anywhere can send to us, concerns or complaints about what a business enterprise is doing that does not align with the UNGPs. And most times when we receive such communications, we review them, and when appropriate, we do issue statements, maybe condemning the business or highlighting what they could have done better. And over the last years, at least, we've received more than 200 communications relating to climate change, which shows a growing interest in this subject of the responsibility of businesses for climate change, both their direct and indirect responsibilities. And of course, I'll highlight what I mean by direct and indirect as we go on. So what I noticed, though, as a member from African states, is that we've not really received any communication from Africa on climate change, which, and as I always say, it could be a sign of 2 things. It could be that there is no problem, or it could be that African civil society actors do not even know about our communications procedure. I want to believe it's the second, not that there is no problem at all, because with issues of gas flaring in Nigeria and in many parts of Africa, with issues of a rise in greenhouse gas emissions in key sectors, especially agriculture and the fast-moving consumer goods, with those issues of greenwashing, like has been mentioned, and the likes, then you would wonder why we are not receiving communications from African civil society actors. I would say that the communications procedure is available online. Anyone can click on the link and send to us whatever you think a business is doing wrong. Maybe they are just pollution, increased pollution, or whatever they are doing wrong. It is important to bring that to the attention of our working group so that we can investigate and where appropriate, we can indeed intervene directly with states and with the businesses themselves. Of course, one aspect of our work that I should also mention is our annual forum. Every year, we convene in Geneva in November to talk about business and human rights, including the role of litigation in providing access to remedy. And we are already preparing for the 13th edition this year in November, the last week of November. If you're not already planning to be in Geneva, we invite you to join us. Either physically in Geneva or online. In addition to that, we have regional forum. The African Regional Forum, for example, was held last year in Addis Ababa at the African Union headquarters, and we're already preparing for this year's edition. And more information on that will follow soon, but we anticipate that this year's edition will be held in September. And so we invite all actors that are interested in business and human rights and environmental justice to join us in the African Forum. And again, like I mentioned, you'll find information on all of this on our website. So that's our summary over the last few years: 18 country visits, more than 1,100 communications, with only a few of those coming from Africa. We've published more than 30 thematic reports on different topics and they are all available on our website. We've organized 12 annual forums. We're preparing for the 13th edition this year. So I haven't summarized our activities. I'll go on to talk about, why corporate climate litigation could be very, very important, and the key trends that we're seeing relating to corporate climate litigation. And when I listened to some of the points made earlier, in the panels, it shows clearly that there is a growing awareness on the subject of climate change. There is growing awareness across the continent on the role that corporate climate litigation can play. And there is growing awareness on the UNGPs, especially the 3 pillars. Of course, when we talk of corporate climate litigation, which has been well articulated by the panelists that spoke earlier on, it provides us the opportunity to achieve or to make progress on the 3rd pillar of the UNGP. So the 3rd pillar meaning access to remedy. Whenever there is a wrong, there should be a remedy. And when businesses emit greenhouse gases, when they fail to address the problem of gas flaring and the likes that exacerbate the problem of climate change, then that is a wrong which requires a remedy. And of course, in access to remedy, we often say that it is indeed the responsibility of states as well as even businesses to put in place means and measures through which anyone impacted by business activities can receive redress. And of course, when we talk of corporate climate litigation, we know that it will fall mainly under state-based judicial mechanisms, which the responsibility of states to ensure that the judiciary is strengthened to be able to handle grievances or disputes relating to climate change. And what we've seen in terms of trends, of course, some of the speakers have mentioned that we've seen more than 2,000 climate change disputes in 38 countries on the direct and indirect impact of climate change on human rights and the need for redress. So we've seen direct claims relating to failure to mitigate and reduce greenhouse gases that cause climate change. For example, maybe lack of ambitious greenhouse gas emission reduction plans by a business. We've seen challenges relating to that when a business says we're going to do this and we're going to do this to reduce our greenhouse gas emission, and civil society actors say, well, what you have said you will do is not even enough. We've seen challenges by civil society actors on new oil or coal licenses being issued to businesses and civil society actors saying, is this how we're going to combat climate change when you are granting new licenses? We've seen direct litigation or disputes relating to use of pollution technologies, plastic packaging, intensive farming, emissions, increasing emissions in supply and distribution. Of course, the indirect aspect relate to efforts by businesses to address climate change, which by itself is resulting in human rights concerns. So maybe a business says, well, we want to address climate change, we want to reduce our carbon footprints, and we're going to do that through increasing our investment in REDD+ projects. And then those REDD+ projects themselves are resulting in human rights concerns. We've seen that as well. For example, failure to conduct corporate due diligence to anticipate and mitigate impact of emission reduction projects on indigenous land and forest. We've seen concerns about failure of businesses to provide to adhere to procedural standards in international law when planning emission reduction projects, lack of access to information, exclusion of women and youths from decision-making processes. And of course, the panelists have talked about greenwashing and climate worshipping, as it was put. Of course, we've not, of course, the concerns we've seen more of is the greenwashing aspect, especially deceptive marketing, saying, oh, there was a recent case, of course, in France with an oil company advertising its lubricant or lubricating oil and saying that it was carbon neutral, but it turned out not to be. So we've seen such concerns relating to greenwashing, the deceptive marketing, and in our General Assembly report, we highlighted some of that in our report on just transitions and the need for stakeholders to avoid greenwashing because of the litigation risks that will pose to them. We've seen issues relating to even what some have described, as this issue of green grabbing, as they've called it, green grabbing, in which you say, well, we are implementing this green project to reduce our carbon footprint, but you are doing so by grabbing lands, by paying. By grabbing lands without compensation. You're doing so also by paying poor wages, by giving making the working conditions worse off, all in an attempt to accelerate climate action. So again, we've seen issues relating to inadequate local content. Stakeholders complaining that, well, even though you have these projects, they are indeed not providing adequate opportunities in terms of goods and services being sourced from the local community. So we've seen a mix of direct consents and indirect consents. And now, and this is a survey of what we've seen globally. The question then is, how many of these are coming from Africa? Just like I mentioned with our communications procedure, in which we've hardly received communications from Africa, we also see that the concentration of corporate climate litigation is in other jurisdictions. In fact, not more than 20 cases relating to climate change have appeared in the continent. According to recent studies, so which again shows that there is a need to address concerns that may be responsible for that. But in terms of cases that we've seen on the continent, of course, we've seen cases relating to licensing and climate change. Like I mentioned, why are you issuing a new oil and gas lease or license or a new coal license to this company when we're trying to address climate change? We've seen the Namibian case of Nkumakara Community Forest Management Association, for example. On that, we've seen the South African Council case, African Climate Alliance, and so on. And of course, the South Durban Community Environmental Alliance case as well. On the issue of gas flaring and climate change, of course, Nigeria often provides case studies on this, given the many years of environmental degradation by oil companies in that country. You've seen, for example, who, of course, the famous Jonas Bemre and Shell case, or, the Center for Oil Pollution Watch and NNPC, in which the Supreme Court of Nigeria indeed said gas flaring is a violation of human rights. And of course, gas flaring also contributes to the problem of climate change. And we've seen cases, of course, we've seen the famous Okpabi and Royal Dutch Shell case. And of course, the case of Mobil producing Nigeria, talking about whether gas flaring is a tax, the tax implication of not complying with gas flaring regulations and the likes. And of course, that's just a summary. Some of these cases are very, very interesting in highlighting the human rights dimensions of gas flaring and climate change. Of course, we've seen cases relating to environmental impact assessment, like our failure to conduct environmental impact assessment can impact can exacerbate climate change. And of course, we've even seen the case of Longowe and Vedetta talking about the duty of care owned by a parent company when it comes to environmental pollution by its subsidiary and the likes. Again, these are some of the few cases that we've seen on the continent. And when you think of how much environmental damage is going on across the continent, then it's worrisome to me as a scholar that when we sit to review cases, then we only find maybe less than 20 or very few, both in terms of litigation and even in terms of communication. So there is a need to reflect on what the gaps may be and how we can address them. I'm so delighted that this conference has provided an opportunity for us to reflect on some of these problems. And I've been taking notes, listening to the problems that have been highlighted by the previous speakers. And I will just summarize some of them, what I call the coherence gaps that hinder corporate climate litigation. This is a question: why is it that with so many of our communities complaining about environmental harm, gas flaring, impact of climate change, greenwashing and the likes, green grabbing, why then is it that corporate climate litigation as a tool for enhancing access to remedy has not taken root and has not really been accentuated in its use? Well, the concerns will include inadequacy or absence of climate change laws. In a continent of more than 50 countries, you see that only very few countries, Nigeria, Kenya, have climate change laws. And even when you see the countries with climate change laws, the question is how much of it is being implemented, and how effective is the implementation. Of course, we've seen some recent progress in Nigeria with the establishment of the National Council on Climate Change, with the appointment of a substantive head of that body, and we've seen such progress, and we hope that that will lead to greater awareness. Because without a legislation, a comprehensive legal framework on climate change, then it will be very, very difficult to talk about corporate climate litigation. Because what we've seen in that case is that, for example, before Nigeria had the Climate Change Act, what we saw was that any attempt to go to court to challenge anything relating to climate change, then you have to go using other environmental legislation or trying to bring it under torts and the likes, and it did not really provide a clear, it did not provide that clear entry point, with many judges saying, for example, well, even though you've talked about this issue called climate change, I don't see how this is a tort. I don't understand how this is a human right violation, because there is no clear law. So if there is a clear legislation, African countries will, in my view, be able to make progress. They will be able to understand the issue more, even in courts. Of course, the absence of national action plans on business and human rights is another reason. Only 3 countries, Kenya, Uganda, and Nigeria, have national action plans on business and human rights, meaning that in many countries in Africa, even though we've been talking about the UNGPs since 2011, awareness is still very, very low. We've been to countries on our visit in which they don't even know there's anything called the UNGPs, especially when you move outside of the capital city. So there is no way we can make progress in using litigation as a tool for advancing remedy when there is, no national action plan. That is, there is no national commitment to the business and human rights agenda. Of course, lack of regulatory clarity on ESG standards and reporting is a primary driver of greenwashing. When we say, oh, greenwashing, you're lying, you're saying deceptive marketing, what is the standard? What does a clear communication mean? What does an accurate communication mean? So lack of clarity on that is a driver of some of the problems. Low public awareness on climate change, on corporate obligation, that has been talked about throughout this conference. Of course, the issue of gaps in data collection as well. There's no way, even trying to measure the number of cases on climate change in Africa is a big problem because of lack of data on some of these issues. Lack of data with respect to climate and energy transition programs, making it difficult to understand which businesses are actually on the right path, which ones are not meeting their goals and targets. Of course, the issue of long delays in litigation has been mentioned, which has led a lot of people to consider ADR, mediation and conciliation, as opposed to litigation, because we've seen cases that have been in court for 20 years, some more, some in which even the claimant and the claimants have died, looking for justice. So there is not there. So which again is a disincentive to the use of litigation as a strategy. Of course, we've heard some of the panelists talk about lack of specialized courts on environment and climate change. Kenya is a positive case study in this regard, with a clear mandate for an environment court. But we've seen slow progress on this in many other parts of Africa, meaning that if you want to, which is again responsible for the delays. If you want, climate change by itself is a time-sensitive problem that requires urgency and quick action. And so when you go to general courts and then your case is listed and it's there for years, it does not really give local communities whose lands and waters are being polluted and whose livelihoods are being impacted by climate change. It does not really give them succor if they have to wait for that long because of lack of specialized courts and tribunals. Of course, even in our courts, the judiciary in many parts of Africa have been very, very slow to issue clear procedural guidance on climate litigation, right? If I am in court, what tools do you have for me as the judiciary to be able to use litigation when it comes to climate change claims? This has been, I was speaking to African judges earlier on, and I was also at the African Court on Human Rights last year, and we were talking about the need for this. There is a need, there is a need for their lordships to come out with the guidelines on how to use. By coming out with such a guideline, you're sending two messages. Number one, that you are aware that corporate climate litigation can be very useful. You are aware of the concept. Number two, you are saying, if you want to go along this path, these are the things you need to do to satisfy us. These are the steps you need to take in terms of gathering evidence, expert witnesses, quantifying damages. These are the things you need to do in order to satisfy us, so that we can understand what you are trying to argue. So I was telling my lords, I said, if you don't come out with such guidelines, it shows you don't even know that there is something called corporate climate litigation. And it means, you are leaving us without guidance, without help on how to come before you to argue these cases. And that's something we will continue to say in our engagements. Of course, the issue of inadequate capacity of the judiciary has been mentioned. And on the part of the judiciary, they say, well, it's not just because we lack capacity on climate, it's also because we lack resources as well. It is easy for you to bring all these new concepts to us. We are open to them. But do we have the equipment? Do we have the tools? Do we have the training? And even do we have the technology? Many of our courts continue to be archaic and with old tools, with judges being forced to write, longhand because there are no computers, with many courts sitting in dilapidated buildings And then you are talking about corporate climate litigation. And what you also find is that because of the failure of government in many parts of Africa to provide these tools, you have businesses providing these tools. You have the same oil company that you are going to sue trying to build a new courthouse for you, so that you don't, the judge does not have to sweat in court. So again, that already raises a lot of issues, and we've seen that in many countries actually, in which you have the oil companies having to build courtrooms for judges, you know. So I've been one of the most vociferous advocates of the need for increased budgetary allocation to courts so that they can do their job, and they can also inquire into these new areas. They can also ensure that their capacity is raised when it comes to some of these new themes. And I hope that African countries will respond to some of our calls in this regard. Increase budgetary funding for the judiciary, providing them the resources and tools, the training to be able to work alongside their peers in other jurisdictions in order to advance corporate climate litigation opportunities in the continent. And of course, there is the big issue of, I asked the question, and I can provide some answer. I asked the question, why is it that CSOs are not suing? Why is it that CSOs are not submitting communications? Some of them will say, well, when we do, we are being penalized. A lot of, there are countries in East Africa, for example, that, there is a rise in attacks on environmental human rights defenders and witnesses, and even whistleblowers. There have been cases in which a judge that has ruled on climate change issue in Africa was transferred. There was some in another country in which the judge for ruling on an environmental case was demoted. So such issues, attacks on human rights defenders, witnesses, whistleblowers, and judges will not advance our jurisprudence in this area. So there is indeed a need to provide, greater protection. And we argue as a working group, we advocate rather as a working group, that even businesses should use their own leverage to speak against attacks and reprisals in this regard. Businesses, as key actors, should speak against it, should ensure that whenever there is evidence of this, they dissociate themselves, because some of these businesses have influence and voices that can assist in this area. And of course, the issue of enforcement is another problem, in which, okay, let's say I went to court and I got a favorable ruling. What happens next? We've seen cases, for example, in the Nigerian Gbemre, a famous Gbemre case, the local communities argue that even since the hearing, there's been no change. The gas flaring continues. So what is the success that we have enjoyed for this hearing, this ruling rather? So the enforcement gap is another key issue, that if we don't ensure that local communities actually feel the reward of their persistence in giving evidence, in going to court, in participating in proceedings, if they don't feel the result in terms of enforcement, then it will not inspire confidence when next they are called upon to participate. So looking forward, what we have done as a working group is to also map out, this document shows the progress, 10 years after the UNGPs, the working group came up with this document to reflect on the next decade of action, to say, well, how can we address some of the key gaps that we still see in access to remedy and the likes in the next decade? And I will just share a few points, in wrapping up on the way forward. Of course, it's quite clear that the way forward will be the need for greater coherence, the need for comprehensive regulatory framework on climate change and on business and human rights. Countries that are yet to adopt national action plans on business and human rights should do so to show their commitment to the business and human rights agenda, as well as to provide clear reference on climate litigation as a tool for advancing access to remedy. There is also a need for clarity, like I've mentioned. The judiciary should provide clear and specific procedural guidance on corporate climate litigation, because what corporate climate litigation will mean in Kenya might be different to what it means in Nigeria. So there is a need for the judiciary in these countries to provide such guidance, which will help judges, which will help lawyers, and it will help experts and other actors to understand this strategy. Of course, in doing so, we note that there is indeed a need to align such procedural guidance with the guiding principle. Guiding principle 31 talks about the need for both state-based and non-state-based mechanisms to demonstrate legitimacy, effectiveness, predictability, right compatibility. And I've mentioned why predictability is important, why enforceability is important. There is a need, to align our processes with all of that. And of course, there is a need to enhance capacity, information, and awareness, promoting education and awareness on business and human rights and litigation, corporate litigation, especially working in collaboration with key actors to bridge the current awareness gaps. And that's why I think that this conference that we're having is indeed a very welcome development, as we have been able to highlight some of these gaps, and it will provide us an opportunity going forward. So let me end by congratulating the organizers, especially the BICL, as well as the other organizers for providing such a wonderful opportunity. Let me commend the organizers also for your projects in this regard and for looking at this issue, which I believe will enhance capacity across the continent. So on behalf of the working group, ladies and gentlemen, I thank you very much for your attention, and I look forward to our further discussions. Thank you very much.
Thank you very much. Thank you very, very much, Professor Damilola Olawuyi. Thank you very much for your very incisive presentation. I thank you for informing us about the work of the United Nations Working Group on Business and Human Rights. I think we gained a lot from that, and we'll see how best we can engage with that particular United Nations body and important work that you are doing. Thank you very, very much. Thank you very much. Yes, okay. We will take a break for 10 minutes, and then we'll come back to the session on the role of NGOs in corporate climate litigation in Africa. Just 10 minutes, and we'll be back. Thank you.